suggest we move on to Chris and Dave and Dimitra. Please recap your study and thoughts about it as it is now.
Thank you very much. So we all have different perspectives on this, and we've worked on different parts of the project over time. So what I'd like to do is to ask Dave to go first and to talk us through very briefly the methodology for our survey, what we found, our contract and property law analysis, and then I'll invite Dimitra to comment if she wants to add anything from a human rights or data protection law perspective, and then I'll have a few thoughts about tech companies as platforms and who we really want to be governing this space. So Dave.
Yeah, just to quickly introduce our research, then I'm sure most of you have seen the video, but basically what we did was we tried to figure out what do contracts of cloud providers say about what happens when the customer dies. So Felicity was talking about Apple's contract being not particularly helpful in that case. We wanted to figure out how widespread is this practice. And so we went to look at, I think it was 22 cloud services commonly used by consumers in the UK. And we found that actually most of them don't say anything on this topic. Most of them just say, okay, you have a personal right to access this service, but they don't say anything about what happens after the customer dies. So that wasn't, I mean, it was an interesting finding in and of itself that it's not something typically addressed in the contract terms, but wasn't hugely helpful because it just leaves a bit of legal uncertainty. What about the ones that did address it? Well, most of them weren't particularly helpful. So as Felicity said, Apple's one typically says, unless we're ordered by a court to do something, we're not going to give anyone access. The Facebook terms say, oh, if you've used the legacy tool, then we'll give that person access. But if you haven't, then we're not going to give people access. And as Michael's pointed out, we don't know how many people are actually using this legacy tool. Certainly, it's not universal that people have a will for their traditional assets. So how many people are actually using these legacy tools for their digital assets? We just don't know. So the contract law analysis basically led us to say, either there's nothing in the contract or there's something unhelpful in the contract, which wasn't really a great finding, so to speak, from our perspective, because we are interested in ensuring that at least the deceased customer has a choice as to what happens to their stuff, but also probably that relatives who want access to valuable digital assets have a chance to access those. So we then left the contractual analysis and looked at, I guess, what Felicity described as some of the thorny legal issues that didn't come up in the Rachel Thompson case, but that might come up in future cases. And I think there's three that I'd just quickly mention. The first is, just as Felicity said, are these digital assets property? So do they even form part of the estate that's being passed on? Is there a property right in the photographs, say, themselves? And that's pretty tricky under English law. It's not particularly clear that they qualify as property. They're certainly not a thing in possession, which is a tangible item. It's not clear that they're a thing in action, which typically refers to a right. And so it's just not really clear that they're part of your estate at all to begin with. Now, courts might in future take a more expansive view of what is property, but certainly at the moment, there's just more legal uncertainty from the property law angle. So we said, okay, let's leave property. Let's look at copyright. If these photographs are stored in the cloud, if they were taken by either the husband or maybe by the widow themselves, maybe they own the copyright. But does that mean they can demand return of the copies of the files? Well, that wasn't clear to us, that they had, under copyright law, a remedy which says, I want my files back. They have a remedy that says you can't copy them without my permission, but could they actually get their stuff back? So that was the kind of copyright law question that we looked at. And then finally, we kind of swung back to the contracts and said, well, what about that contractual right of access? Could that be a thing in action which could pass on through the estate? And that's when we looked at the terms again. And as they said, well, these are personal rights of access. So it wasn't clear that those would form part of the estate, being personal rights, which typically would not pass on to your heirs. So that's a little what we looked at. Kind of like Felicity, we would have quite liked to have seen a test case in which, I mean, it's great that courts are giving these orders because it means that that particular widow can access her photographs, but we'd like to see a test case go through and set some real standards in this area, or potentially highlight that there's a gap, in which case maybe we could get some legislation from the government to address this, as we've seen in other jurisdictions. So yeah, that's what I wanted to say about the findings of our research. Dimitra, did you have anything you wanted to add?
Yes, I'm sorry if you hear a lot of noise because they're doing some works in the next door building. So yeah, very briefly, what I wanted to say is the way a lot of our discussions before writing the paper and before even doing the analysis was between this distinction between what the law actually says and what the contracts say, and what we thought was expected by the heirs potentially, who do not know the law and do not know these issues about property rights or copyright, and but what they would expect, judging from the previous experience of the analog of the offline world. So they would expect to get access to, the widow would expect to get access to her husband's letters, for example, or photographs. But now, obviously, this is very unclear whether that's the case in the online world. So I think a lot of our discussions, and I thought were particularly interesting, was this disconnect between what is actually what the law says, what the contracts say, what is expected by heirs, and what potentially, should the law change to match those expectations, or also to match what we think is more fair. So yeah, that's I thought it would be interesting to add that, because that's where all our discussions came from. And I'll pass on to Christopher now.
Thank you, Dave and Dimitra, very much indeed. And I should say to others that if you have stamina, we would love to get your reactions to the various papers we've put out. There's 3 on SSRN. There's a chapter in a book which I'm going to shamelessly promote, which is being published this week, which is the 2nd edition of Cloud Computing Law, Oxford University Press. And we're still working on this. And we, as Lillian said, this is a very rich seam to mine, and all of us have plenty more work we could do just on the legal aspects, never mind all the other fascinating issues that everyone else in the room has expertise on. Excuse me. So rather than talk some more about our research, I want to go off piece slightly and respond to comments from Lillian and Michael, because I have a hunch that I'm going to be the only person in here who might be prepared to take a contrary view. And I do have a bit of reputation anyway for being contrary. So Lillian has said, and the recording will tell me if I've got this wrong, but broadly speaking, I heard her say something like, well, now we don't trust digital platforms at all. And Michael said something like, well, platforms are established players and they have no interest in going to higher courts to protect us. So I just want to briefly respond to that. And in terms of transparency, since that's a big theme today, I should say that I am also a practicing lawyer as well as being an academic, and I've been working in the City of London since the early 1980s, advising technology companies and their clients, including some of the companies that will be discussed here today. But I'm not here to defend big tech. I just want to say, in response to those comments from Lillian and Michael, that the whole question of platform governments is enormously complicated, because it's not just big tech that have conflicting interests. I mean, you have to be careful what you wish for. If you don't want big tech to regulate this space, who do you want? Do you want your governments? Do you want some new regulators? We already have dozens in this space. Do you want the courts? If so, how on earth is this going to be scalable? So you probably know this, but the big tech companies employ tens of thousands of people full-time just to work on content moderation and to respond to people exercising their rights under data protection law and other legislation, and to deal with responses from law enforcement access and governments for access to data. And in fact, they, contrary, I would say, well, that's a bit strong. Just to give a different perspective from Lillian and Michael's, what I have seen in practice is that some of these tech companies are willing to pour enormous resources into fighting cases where they believe it's inappropriate. For example, for the FBI to have access to someone's iPhone, or for somebody in the context of a law enforcement case in New York State, just on the say of a magistrate, to have access to somebody's email in a cloud server in Ireland. I mean, there are many cases like this. Indeed, a recent case, which I'd love to hear from Lillian about, and I only know the bare facts of this, is, but just in the last few weeks in the UK, Apple and Google have refused to put on their app stores a revised version of the UK government's COVID track and trace app, because contrary to commitments made by the government a few months ago, this new version would include location data collection and tracking and matching. And now you may think Apple and Google have their own cynical agendas, and I'm very happy to discuss that. But it's interesting that it took the big tech companies to push back on the government, say, no, we will not put this on our app store because it's contrary to the principles that were agreed in terms of data collection, minimization, and secondary purpose uses. Lillian, you want to come straight in on that?
Sorry, I shouldn't really just distract it off into us, but it's funny because that was a bit I had in what I wrote, which I've now lost because I'm not very organized today, which I left out because I thought I was still talking too much. So what I actually said, if I can get hold of it in what I wrote here, because you're not a mind reader, was notably, yeah, okay, I was being argumentative as well. Notably, we don't trust these platforms at all to act in our interests anymore, as opposed to their own. Sometimes they will instrumentally act in our interests because it furthers their interests. And even when they do, the control it gives them worries us. And the exact example I cite is the Google Apple emission notification contact tracing apps, where yes, my end of the world would argue that they're doing something good, but why are they doing it, you know? And it's partly
exactly
because...
Look, Lillian, I think we're on the same page. I agree with you. I don't want them to do this. And by the way, I know the senior people in these companies, they really hate doing all this stuff. They'd rather not. They don't want to employ tens of thousands of people to deal with data protection and content moderation.
So I think,
but nobody else will pick up the tab. I mean, governments won't do it. Regulators clearly don't have the resources. Civil society can only do sort of test cases or occasionally bring class action cases. But there is nobody else at the moment to step into this void that I know of. If you can tell me there is, I'd love to hear who it is.
No, I think we're violently agreeing. I mean, I think you've heard me give enough talks in which I've said, you know, I'm very sad for intermediaries and ISPs, as you used to call it, the ISP sub-story, you know, stuck between the rock and the hard place, in that governments don't want to spend the money, don't have the technical expertise, and don't want to be seen as the bad guys, and therefore they enroll the intermediaries to do all these jobs of preventing abuse, filtering, monitoring, etc. Whereas, yeah, the intermediaries would like to be intermediaries. The trouble is they're not. They're not. They're now the repository, perhaps, of the main site of power in the digitized, industrialized West, you know? So I think they can't just be too disingenuous about that. But actually, I wanted to float a theory, which is that the reason why companies like Apple, and this is not always true, but if you look at the Yahoo case as well, and I think also one of the ones in Brazil, why they are not keen on just giving in to what seem totally reasonable requests from grieving widows to get hold of stuff in the iCloud is because they see it lumped in with general requests for access to stored communications, which you know more about than me. But it seems quite possible to me that they're seeing this as the thin end of the wedge. And you've got all the stuff with the Microsoft Apple, not Microsoft, the Microsoft Ireland case, you know, which kind of rolled on into the Cloud Act, which I was also going to talk about. And yeah, do we think that's a viable, do we think that's a reasonable approach? Do we actually think it's reasonable that they lump together the fears of access to data while people are alive to the fears of access to data when people are dead? I mean, one thing I thought you would say is that we do invisibly take up normative positions on this. You know, what's good for business, what's good for relatives, what's good for the deceased. And it's very, very hard to do anything except try to make those explicit.
Can I just make one further brief comment from the lawyers' camp, and also still in response to this question that the big players will never fight these cases and spend money on them. I mean, for those of you who are not familiar with it, the so-called Google Spain Right to Be Forgotten case is, I think, directly relevant to our discussion because it's about remembering and forgetting and being able to manage your profile in society while you're living or after you've died. And very briefly, in this case, Senor Costella, a Spanish lawyer who at some point in the past had been involved in bankruptcy proceedings related to unpaid property debts. And I don't know any more detail than that. However, what happened was, and this was decades ago, the fact that he was found to be a bankrupt was published in a newspaper as required by law. This is a public record. So we get into my earlier comments about, do we want to rewrite history? And Mr. Costella asked Google to remove this from their search engines. And he also wanted the newspaper to suppress it. Now, the newspaper is a print thing in a print archive in a, in a library. So we're getting very close to the dystopian science fiction scenarios here, where people suddenly have powers. And it might just be, not just be governments, it might be private sector actors to burn books and to burn newspapers and to change the historic record. And personally, I have a kind of, I'm very unhappy with that. And the trouble with this so-called right to be forgotten is that, again, it puts these platforms, these intermediaries, in the firing line. And so the compromise briefly in that case, when it went all the way up to the Court of Justice of the European Union, was that the library didn't have to burn the newspapers and Google didn't have to completely destroy all the historical records. However, in this case, Mr. Costea had a right to be delisted in searches against his name, so that he was still there in the search engine, but he did not appear prominently in the results, although Google in response was able to put a notice up saying some of the results on this page are maybe incomplete due to legal or other action. And again, I'm sorry if I sound like an apologist for big tech here, but within 2 weeks, Google had put up a form allowing anybody in the world to apply for delisting. And it had hired an army of people. It couldn't get them all in-house, so it outsourced a lot of it. Then it hired a load of people just to review these forms. Now, there's nobody else would do that. It's all very well for the Court of Justice to hand down a judgment. They're not going to manage this. The national data protection regulators, no way could they take this on. Now, I suppose the ultimate irony of this case is that Mr. Costea, a lawyer, is now the most famous forgotten person in the history of the world, at least amongst, this kind of geeky lawyer community that some of us swim in. So I do think there are very complex issues here. And I wouldn't assume that I agree that the tech companies, like all of us, we have mixed motives. We have many interests. But there are documented cases where they've spent a lot of resources, time, money, people fighting these cases.
Okay, so thanks. I'm just sort of an interim summary. So we have the issue of the power of big tech, and are they good or bad inherently in some way? I would argue that we need to think in terms of are they responsible and accountable, rather than if they're good or bad per se, sort of. In the chat, we have the issue which has come up also of the comparison of the analog to the digital situations. And also the remembering, forgetting, memory, whether on an individual level, like the right to be forgotten, or on more social kind of levels.